All these people were initially given parole. If you're here, if you're present in the US under parole, you're not subject to expedited removal. The government doesn't have that option. So what the government is doing here is they're saying, all right, well, you had parole and we couldn't expedite your removal from the US, but we're now ending your parole, and having ended your parole, you no longer have parole status, and now we can subject you to expedited removal. That's Trump's position. The position of the plaintiffs, which the Judge Indira Telwani bought, was that no. If you've ever been present under conditions of parole, that permanently excludes you from expedited removal, even if your parole status has been expired or terminated. Get the difference? All right, let's get to the second decision here. This is not exactly the same legal issues, but the same group of temporary protected refugees: Cuba, Haiti, Nicaragua, Venezuela. Slightly different issues, slightly different outcome. And of course, ultimately, this will all be worked out at the Supreme Court level. Now, these judges were 2 Biden judges and 1 Obama judge. So all of these are left-wing judges. And yet they unanimously ruled, no split decision, 3-0 in favor of Trump. So let's get to this. Let me grab my pen. This appeal centers on the executive branch authority to categorically terminate parole grants under the Immigration and Nationality Act. Parole permits a non-citizen to enter the United States temporarily while investigating eligibility for admission to take place. Besides allowing legal access to the U.S. with the ability to work, oh, that's nice. So they're already consuming employment resources. In some cases, they receive federal benefits. Why are third world migrants getting federal benefits? Do I get federal benefits? I mean, I'm just an American citizen paying for the benefits. In some cases, they receive federal benefits. A grant of parole does not per se confer additional rights upon a non-citizen. The Immigration Act empowers the Secretary of the Department of Homeland Security to grant parole of non-citizens into the U.S. only on a case-by-case basis for urgent humanitarian reasons or significant public benefit. Is that what Biden was doing when he let tens of millions of third world invaders into our nation? Legally, legal status, they're here on parole status. Many presidential administrations have invoked this authority to grant parole to non-citizens. Most relevant to the instant appeal, DHS under President Joe Autopen Dementia Biden launched a parole program under which the nationals of Cuba, Haiti, Nicaragua, and Venezuela, CHNV, who met certain categorical, not individual, categorical criteria, could seek discretionary individual grants of parole into the U.S. for up to 2 years. Between October 2022 and January 2025, about 500,000 individuals received grants for parole under the CHNV program. But when President Trump took office, January 20th, the day he was sworn in, he signed Securing Our Borders executive order, directing DHS to terminate all categorical parole programs that are contrary to the policies of the U.S. 2 months later, DHS published termination of parole processes for Cubans, Haitians, Nicaraguans, and Venezuelans, announcing it was terminating the CHNV parole program. Among other actions announced in that termination notice, they revoked all existing grants of parole in a month's time, rather than letting each expire at the end of the individual 2-year period. You must all go home right the F now. Plaintiffs, CHNV parolees, all of whom were affected by the revocation of parole, filed suit, sought a stay in the United States District Court for the District Court of Massachusetts. And the judge there, the unelected black-robed, tyrannical inferior district trial court judge there, is Indira Telwani. Classic American name. This one was born in the U.S., born in New Jersey. I don't know if she was born to American citizens or third world invaders, which would make her not an American citizen. Invaders do not grant birthright citizenship to their children just because they were popped out on American soil. I wonder if I can find out quickly. Should I look to see if her parents were migrants? Let me see. Let me see if Grok can tell me quickly. Look at this. Oh my God. She's not an American citizen. She's another foreign national federal judge ordering about our president. Look at this. This should horrify all of us. Were the parents of federal judge Indira Telwani, the unelected black-robed tyrannical inferior district trial court judge who ruled against Trump in this case, were her parents American citizens when she was born in New Jersey? Grok says no. The parents of federal judge Indira Telwani were not American citizens when she was born on October 6, 1960 in Englewood, New Jersey. Her father, Manik Telwani, was born in Punjab, India in 1933 and immigrated to the U.S. in the mid-1950s to pursue graduate studies in geophysics at Columbia University, earning his PhD. In 1959, her mother immigrated from Germany around the same time. Reliable sources, including her Wikipedia entry, Senate confirmation records, and obituaries, describe Telwani as the daughter of immigrants from India and Germany, with no indication of them being naturalized before her birth. So she, under any proper understanding of American immigration law, Indira Telwani is either an Indian or a German national. She is not an American citizen. Horrific. Why can't we find natural-born Americans who are American citizens to be our federal judges? Do we not have enough people? A nation of 340 million people? Why do we keep putting into federal bench positions non-American citizens? Does any other nation do that? The district court of unelected black-robed tyrannical inferior federal judge Indira Telwani, an Indian/German national on the American federal bench, granted the preliminary injunction request, certifying a class of individuals, so not just the plaintiffs before her, but another universal injunction, a class of individuals paroled under the CHNV program, and freezing Trump's termination notice. So ordering our elected Article 2 executive branch president around as if he were a mere clerk in her court. The government appealed. For the reasons explained below, we, this Court of Appeals, a 3-judge liberal panel, freeze the order of Judge Indira Telwani. This was Biden-Obama judges. Because the text and legislative history favor the government's position, we conclude the plaintiffs have not demonstrated a strong likelihood of success in establishing that the statute requires the secretary to end grants of parole on a case-by-case basis. The district court, therefore, legally committed error in issuing injunctive relief. What about the APA argument? Was it arbitrary and capricious to terminate parole? Or did the Trump administration have a reason? The alleged legal error. The APA instructs a reviewing court to set aside agency action that is arbitrary, capricious, an abuse of discretion, or otherwise not in accordance with law. An agency's decision is arbitrary and capricious if the agency relied on improper factors, disregarded an important aspect of the problem, offered an explanation that runs counter to the evidence, or when a reasonable explanation of the agency decision cannot be discerned. Agency action that is premised on a legal error runs afoul of this standard. The unelected black-robed tyrannical inferior district trial court judge Indira Telwani, a citizen of India, Germany, determined that the third world migrants here were likely to prevail on their argument that the decision was based on obvious legal error, the decision to end parole. The secretary's explanation for termination rested on the premise that the Immigration and Nationalization Act prohibited the use of expedited removal proceedings for prior parole recipients who had been continuously present in the country for at least 2 years. DHS explained that it sought to terminate parole early for existing parolees rather than permit their parole to naturally expire to minimize the number of people who would have been otherwise been ineligible by statute for expedited removal proceedings by virtue of their 2-year continuous presence in the United States. All these people were initially given parole. If you're here, if you're present in the U.S. under parole, you're not subject to expedited removal. The government doesn't have that option. So what the government is doing here is they're saying, all right, well, you had parole, and we couldn't expedite your removal from the US, but we're now ending your parole, and having ended your parole, you no longer have parole status, and now we can subject you to expedited removal. That's Trump's position. The position of the plaintiffs, which the Judge Indira Telwani bought, was that no. If you've ever been present under conditions of parole, that permanently excludes you from expedited removal, even if your parole status has been expired or terminated. Get the difference? The trial court of Indira Telwani agreed with the plaintiffs that the statute does not subject persons who were authorized to enter the U.S. to expedited removal, regardless of how long they have been in the U.S. So if you're ever under parole, you're forever free of the risk of expedited removal. Judge Indira Telwani reasoned the premise of DHS's preferred rationale for terminating parole for existing recipients was faulty in this respect, that parole could be terminated and then allow for expedited removal. We, the Court of Appeals, addressed this issue mindful of the burden of the migrants in the context of a stay to demonstrate a strong likelihood of success. We cannot agree that they've made that showing here. The Immigration Act permits only those who have not been admitted or paroled in the U.S. to be subject to expedited removal. The parties reasonably disagree on the meaning of have been paroled in this context. Plaintiffs and Judge Indira Telwani reasonably read the language to mean those who have been granted parole at some point, at any point in the past, are not subject to expedited removal, whether or not that parole has since been terminated. Viewed this way, no prior recipient of parole can be subject to expedited removal. The government, on the other hand, reasonably reads the have been paroled to refer to those with the current status of being paroled, not being subject to expedited removal. Under that reading, the statute clarifies that people who are currently paroled may not be subject to expedited removal. However, it does not impose a categorical ban on the use of expedited removal for those whose past parole has been terminated. Both readings are plausible because, as plaintiffs point out, parole can refer to both a manner of entry, they were paroled at some time in the past when they came into the country, and a current status. Do they have the current status of being in a state of parole? Similarly, the present perfect tense, have been paroled, can be used both to denote an act that has been completed and to denote an event that continues to be true in the present. Although both sides offer regulations in support of their interpretations, the fact that different regulations appear to support both interpretations does not shed light on which interpretation Congress intended, because Congress passes statutes, not regulations. Since the government's interpretation of the statute is persuasive enough, we cannot discern a clear legal error, as the trial court put it, in Trump's reasoning proffered in the termination notice. We are therefore unable to conclude that the plaintiffs have made the required strong showing that the agency action was arbitrary, capricious, an abuse of discretion, or otherwise not accordance with law. In other words, in immigration matters, we defer to the president unless he's made an obvious, a clear legal error. And that's not the case here. There's a reasonable interpretation of the statute consistent with what Trump is doing. As additional, independently sufficient reasons supporting freezing the judge's order, the district court concluded that the termination was arbitrary and capricious. Judge Indira Telwani concluded this in part because the termination notice did not attend to any of the humanitarian reasons underlying the creation of the program, and because the significant reliance interests at stake, which the termination notice recognizes: aliens departing their native countries, incurring travel expenses to the U.S., obtaining housing and means of transport. I thought we paid for all this ourselves for them. And building connections in their communities. That all required Department of Homeland Security to give a justification for terminating existing grants of parole within 30 days instead of waiting until the original termination date. We disagree, the three-judge Court of Appeals. We conclude the plaintiffs, the migrants here, have not made a strong showing that they are likely to succeed in demonstrating the Secretary's actions were arbitrary and capricious because she provided a reasoned explanation for terminating grants of parole. The APA mandates an executive agency's exercise of discretion be reasonable and reasonably explained. The change in position doctrine, which applies when an agency changes existing policy, is relevant in assessing this action here. Under the doctrine, agencies are free to change their existing policies as long as they provide a reasoned explanation for the change, display awareness that they are changing position, and consider serious reliance interest. To satisfy that requirement, it provides a good reasoned explanation for its action. The agency must show that there are good reasons for the new policy. The Supreme Court has clarified that the agency need not demonstrate to a court's satisfaction that the reasons for the new policy are better than the reasons for the old one. It suffices that the new policy is permissible under the statute and that there are good reasons for it and that the agency believes it to be better, which the conscious change of course adequately indicates. This means that the agency need not always provide a more detailed justification than what would suffice for a new policy created on a blank slate if there hadn't been a pre-existing regulation that was being changed. Of course, the agency must consider the impact the policy change will have on any serious reliance interest. To do so, it must consider whether there are reliance interests, determine whether they are significant, and weigh any such interest against competing policy concerns. On the other hand, review under the arbitrary and capricious standard is narrow, and this court may not substitute its judgment for the judgment of the agency, even if it disagrees with the agency's conclusions. Here, the parties disagree with the scope of the reasons that we should review under the termination notice. The migrants say we should examine only the reason given in the section of the termination notice that addressed the effect on termination of current parolees. The reason listed there was DHS's interest in preserving the ability to pursue expedited removal, which the migrants contend was a legal error. We've already addressed that. It was not a legal error. In contrast, Trump argues that we should also include as reasons all of the reasons in the termination notice more generally, concerning, for example, the cancellation of the parole programs moving forward and the denial of all pending CHNV parole applications. This was the issue in the prior case we just read out of the Ninth Circuit. That concluded that Trump can deny parole for those pending who said, oh, we're about to come in. Those additional reasons also include the Secretary's assessment that neither urgent humanitarian reasons nor a significant public benefit warranted continuing the program, that the parole programs had not improved border security as promised, that parolees were competing for limited resources, including public benefits, with American citizens, and that parolees were exacerbating immigration systems backlogs. The DHS Secretary also stated the parolees' reliance interests are minimized where, as here, the grants were discretionary, limited to 2 years, and they've been here longer than that, and DHS repeatedly warned that these benefits could be revoked at any time. We, the three-judge panel, agree with the government that reviewing all of the reasons stated in the termination notice better accords with our deferential standard of review. Unlike the Supreme Court decision in Regents, the case of Regents, where the Secretary did not address the reliance interest of the DACA, the Dreamer beneficiaries, in terminating the policy, here the Secretary of DHS considered and addressed the reliance interest of the CHNV parolees. So Trump learned from that prior error. The migrants, of course, disagree with the Secretary's reasoning and the weight that she gave their significant reliance interest. But while we have no doubt that many parolees have conducted their lives based on a hope that the parole would run for a full 2 years and perhaps serve as a bridge to further immigration opportunities, of course, they never want to go back to their own shithole countries. They want to stay in America. The Secretary nonetheless considered the impact of the premature termination on the reliance interests of the parolees and their supporters in the U.S., so we cannot say that the Secretary's explanation was so deficient that the migrants have made a strong showing they're likely to succeed on the deferential, arbitrary, and capricious legal standard. Finally, we note that the Secretary explained that humanitarian considerations are best addressed on a case-by-case basis because that approach would be more consistent with the statute and would take into consideration each person's specific circumstances. In other words, we can revoke parole for everybody instantly, and then if any individual needs parole, they can apply again. Although this statement is somewhat conclusory when read in combination with the other reasons given throughout the termination notice, it does not seem so deficient as to enable the migrants to make a strong showing of a likelihood of success on the merits. Our conclusion is bolstered by the brevity of the department's original explanation of the humanitarian reasons undergirding the creation of the CHNV program. It is difficult to fault a conclusory explanation for a change in policy when the basis for the policy was similarly conclusory. In sum, we hold the migrants have not made a strong showing. They're likely to succeed in showing the Secretary's decision to terminate the parole program exceeded her discretion. We also conclude the migrants have not made a strong showing. They are likely to succeed in demonstrating the termination is so insufficiently reasoned as to be arbitrary and capricious. We recognize the risks of irreparable harm persuasively laid out in Judge Indira Telwani's order that parolees who lawfully arrived in this country were suddenly forced to choose between leaving in less than a month, a choice that potentially includes being separated from their families, communities, and lawful employment, and returning to dangers in their home countries. Or that was one option, or staying after the loss of parole status, which means the risk of removal proceedings and detention, including expedited removal, the loss of work authorization, and potential effects on their eligibility for other forms of immigration relief in the future. In other words, they were going to lose the free housing, free medical care, free employment opportunities, free education, free cash money, because they'd no longer be in that protected status. But absent a strong showing of a likelihood to succeed on the merits, the risks of irreparable harm cannot by itself support a stay. You need both. You need likelihood to win and irreparable harm. Even if the irreparable harm is large, is huge, if you're lacking a likelihood to win, you don't qualify for the injunction. Given this conclusion on the most critical factors, likelihood to win and irreparable harm, we need not consider the other two factors for an injunction, balance of the equities, and public interest. For those reasons, we vacate the order of unelected black-robed tyrannical inferior district trial court judge Indira Telwani. Trump is allowed to end parole and throw these people out of the country. Expedited removal of these 530,000 Cuban, Haitian, Nicaraguan, and Venezuelan third world migrants infesting our nation and consuming scarce American resources, housing, healthcare, education, employment, social services, cash money, like the human locusts they are. It is so ordered. So a 3-0 win for Trump, a 3-0 win on this 3-judge panel that was a Biden judge, and an Obama judge. Solid work.